Hi there. Continuing with our day in the life of a small business employment attorney video series. My name is Scott Shibayama. I'm an attorney and the employment attorney and founder of Vision Law Corporation, which represents small businesses only. So today, this is like not necessarily a daily experience for me, but it comes up quite often in my practice. So day in the life in the sense of it's coming up daily, if not, well, not daily, but often. And it relates to trying to get employees to show up and do their jobs. So we'll be talking about three major types of leaves of absence and how to handle them, because it can be quite challenging. Most employers think, my employee's offered a couple months, why wouldn't I have the at-will right to terminate their employment? And it actually causes great confusion to employers, because oftentimes what happens is employee starts calling out sick, on a regular basis, but then all of a sudden they're sick for a week, but they come back to work. And then they're missing more time, and then they need more time off. And employers are very frustrated because they don't have that employee to do their the key position that they were hired for. They're always gone, and you feel like you want to replace them. So, but you can't necessarily. So which laws say, there's tons of leave laws, right, under California law, but the main ones that we'll talk about is the California Family Rights Act. There's a federal equivalent of that, which is the Family Medical Leave Act, FMLA. California Family Rights Act is California law. It applies to any employer with at least five employees. FMLA, the employer has to be a little bigger, has to employ at least 50 employees. So we're mainly in California concerned about the California Family Rights Act, the CFRA for short. But CFRA, FMLA, I'll talk as though it's the same leave law. A lot of similarities between the two. The next one is pregnancy disability leaves. And the third one is disability leaves for mental or physical disability as a reasonable accommodation for that disability. And that's kind of a insidious one. When we talk about it, you'll see that, wow, really? I have to do that? You don't have to, but it's in your best interest to do it. So first example, somebody has a medical condition and they need time off work. And it starts with the first doctor's note, patient placed off work from date 1 to such and such date. Let's say it's a month, 30 days. And employer typically will say, yeah, no problem, without even thinking about it. Sure, you have a medical condition, you need some time off, no problem. But then what happens is what I call the string of doctor's notes, and we get one doctor's note after another, and before you know it, the worker is out 2 months, 3 months, maybe even 8 months. And unfortunately, I don't get the call until that's the case. And then there's major frustration from the employer because, hey, my employee's been gone for 8 months. Can I fire them? No, you can't, unfortunately. When they're out that long, there's like a lot of, we're not supposed to assume in the law, but there's information that probably causes us or tells us we should have known there's some issue going on, right? Either a medical condition or maybe some sort of physical or mental disability. But we don't know, because all we do is we get the string of doctor's note, patient placed off work, and they just line up. Okay, so when I get that call, I have to tell the employer, we really need to set this up for termination because the employee has certain rights to leave, time off for leave of absences, but we have a right to hold them accountable to that time. So for example, for a serious health condition, which i.e. a medical condition can meet that definition under the CFRA, for an employee's own serious health condition, they can get up to 12 weeks off. So boom, 3 months right there. If they meet that, they have that need, then we're obligated as an employer to provide them that time off. And by the way, not only are we required to provide the 12 weeks off, we need to designate the time specifically as CFRA leave, one, and two, we have to put in writing that the employee's job is protected, i.e. that at the end of this leave, if you return to work, we will return you to the same exact position. Now, it doesn't have to be necessarily the same exact position, but substantially similar position. So same rate of pay, same types of hours, same level of responsibility. So not exactly the same, but more or less it's a substantially similar job position. And so 8 months in, I'm having to tell the employer that, look, we didn't send them any CFRA certification, no notice, nothing in writing typically. And so we have to start that process now if we want to limit more time off. They're already off for 8 months, but let's start now to limit their time off to another 12 weeks at a minimum. Or we can just do nothing and just leave the employee off. I mean, we're not paying for them. They're not really hurting us other than we don't have that person in the job. And if we can sustain the business without the employee there, that's kind of like the path of least resistance and, low risk. If we're not taking adverse action against the employee, we're not firing them, for example. We just leave them off on an extended unpaid leave of absence. But what goes hand in hand with the CFRA 12-week leave is a disability leave of absence as a reasonable accommodation for physical or mental disability. So sometimes it's hard to know whether the person has a serious health condition or whether or not they have on top of that a disability. And the definition of a disability under California law is quite broad. It's anything that affects major life activities. So if you think about that, that's extremely broad. I mean, physical or mental disability that affects, physical mental impairment, I should say, that affects major life activities. So in fact, I'm disabled because actually I have a macular hole in my right eye, which means that I've got like my retina has a hole in it. So if I close my left eye, I can't see anything. And it does impact my depth perception, things like that. So it affects my, daily life activities, right? But anyway, back on point. If somebody has a disability, then we are obligated to provide a finite leave of absence, unpaid, as a reasonable accommodation. In other words, we're required to reasonably accommodate physical or mental disabilities. One form of a reasonable accommodation is a finite leave. We have to set that up, finite leave. What does that mean? We need to send them a medical certification for physical or mental disability, just like we would send them a CFRA certification. Ask the employee to get their health care provider to fill out these forms and return them to us within, say, 21 days minimum on the first kind of request for this certifications. And typically, I'm telling my clients to send them both out at the same time so that we can kind of run the 12 weeks of required CFRA leave concurrently with any potential finite leave of absence for disability. And basically that form, finite leave, or that's MedCert for physical or mental disability, has a section on it where the healthcare provider has to fill out specific language that says employee is off work from this specific date to this specific date in the future, and that period of time off will be able to allow the employee to return to work and perform the essential functions of the job after the termination of this finite leave, with or without further reasonable accommodations that don't necessarily include yet another finite leave. So the idea is we give that finite leave, employee needs to return to work, and if they don't return to work and there's no accommodation or they just refuse to return to work, then the employer is in a better position to terminate employment because they've exhausted all of their CFRA leave, 12 weeks, plus, another, month or so of disability leave, finite leave, disability leave of absence. And we need to set that all up. So we need to send emails to the employee, attach these forms, give them a deadline to return the forms, and oftentimes they don't do it, right? All kinds of excuses. Well, I can't see my doctor until XYZ date or whatever. So we're not going to just fire at that point because they have not complied with our request. We're going to send it to them again. At least that's my advice. Do it again. Same forms. Here it is again. We gave you a deadline last time. You did not provide it within the deadline. We'll give you another chance. Here are the forms again. Get with your healthcare provider, and then we can give them a shorter deadline now. Maybe 7 days, 7 to 10 days, 2 weeks, something shorter. And we say, listen, you must return these forms. Otherwise, we can't evaluate whether your leave of absence is authorized, and we may or may not authorize any further leave of absence. Okay, and so typically at this point, they finally return the forms, and we get the forms back, and the doctor fills it out, CFRA form saying, yes, they have a serious health condition, then we're obligated to give them at least 12 weeks. The med cert for disability comes back, finite leave of absence for 3 months, let's say, not beyond, but I guess 12 weeks is 3 months. So let's say we send the forms out at the same time, but the finite leave comes back 4 months is the return date from the finite leave of absence. So we give them the 12 weeks, we give them another month, and we see if they're going to return to work or not. What happens then? They return to work, we're going to have to return them to the same exact position. If they don't return to work at that point, then not without risk, but we have complied with our obligations under the law, have provided the required time off, person's not returning to work, and so therefore, in theory, we can terminate the employment. What happens if they don't return the forms after multiple requests? In my mind, that's another reason to terminate employment. Now you're just off work for whatever amount of time. Could be 2 weeks, 3 weeks, 8 months. It's all unauthorized because we've asked you to have your healthcare provider fill out these certifications to allow us to evaluate whether the law applies to you, and therefore we must provide the leave, in which case it's authorized, of course, and you're refusing to do that. You're not cooperating with us. We can't evaluate your time off. You're also being insubordinate, if you will. And so therefore, we probably say things like, we consider you to have abandoned your job, to try and soften, the risk of us flat out saying, you're terminated. Well, no, you haven't cooperated. You're on an unauthorized leave. So we consider you to have abandoned your job. All of it's not without risk. It's just very challenging to deal with these sort of situations. So what is the worst case scenario is a pregnant female in the workplace in terms of leaves of absence. Why? Because under the CFRA leave, a pregnant female gets 12 weeks off. They do not have to be disabled. They do not have to even have a medical condition. They can have the time off for birth of the child and baby bonding time. And by the way, this leave also applies to men. So the spouses or the significant other, well, I shouldn't say significant other. I don't know that the law does apply to significant others, but spouse, let's just use that as an example. Husband can get up to 12 weeks off for baby bonding time as well. But getting back to pregnant woman, why is it the worst case scenario? You guaranteed you need to give that time off. Then if your female employee is disabled, that's the key word, disabled, due to pregnancy, childbirth, or related medical conditions, then she gets up to 4 months off on top of the 12 weeks off. So roughly 7 months off relating to this pregnancy. The key is she has to prove that she's disabled, but that's usually easily done. They get a doctor's note saying they're unable to work for these 4 months. And so there it is. They're protected. 4 months of pregnancy disability leave. It does not have to come all in 4 months in a row. It might be some time off due to conditions during pregnancy. Morning sickness, for example, might even qualify as reasons for allowing time off for pregnancy disability if it's so disabling that the employee cannot work. Employee might need bed rest at month 3 in the pregnancy, and that would be considered time off. Maybe it's for just a week, but time off for pregnancy disability leave because she's disabled due to pregnancy. But the point is, we're already talking about a long time for the pregnant female to have job protection, and it's all job protected. Oh, by the way, and I should have said, to the extent that you provide medical coverage or group health, either pay 100% or a portion of the premium and make the employee pay a portion of the premium during a CFRA leave and an FMLA leave and a pregnancy disability leave. Employer must maintain the coverage, group health coverage, under the same terms and conditions as though the employee was still working. Now, if the employee was responsible to pay premiums, 50%, employer can require the employee to pay that premium. Hard to collect though, because they're not earning wages, you're not deducting it from their paycheck, and so they need to actually cut a check. And realistically, is if they don't cut a check, you could theoretically send them a COBRA notice because they're no longer working. They're working 0 hours really, and under COBRA, that's considered a qualifying event. And you get with your group health broker and send a COBRA notice, and you might be able to terminate the insurance under those grounds. Why? Because they have an obligation, your employee, to pick up their fair share if that's what was happening before they went out on leave. Okay, so back to the length of time. 7 months. It's a long time to hold somebody's position. But then the person might still be disabled generally, and you might be obligated to provide further time off if there's a legitimate disability that somehow relates to the pregnancy. And so that becomes very messy too, trying to figure out when somebody's on a pregnancy disability leave, that's not considered, the general disability, right? Mental or physical disability. That's a special, quote, disability that has special protections. And so, they might have additional protections if they are disabled under that broad definition of California law, affects major life activities beyond the 7 months. So that's why it's kind of the worst case scenario. All of these situations are very tricky to deal with. Comes up quite often in my practice because people are out all the time for various reasons. And this is just tip of the iceberg. These are the major laws that apply, but trust me, there's all kinds of other laws under California law that could protect an employee. With that, there's a day in the life of an attorney with respect to employment attorney with respect to leaves of absence, major ones, and trying to get people to show up and do their job. Aloha.